For the first issue, where the concern has copyright over the book. In order to obtain a copyright over a work, concern has to fulfill the requirements stated in Section 7, Clause 3. In the case of Honda Giken Kogyo Kabushiki Kaisha against Allied Pacific Motor, it has discussed the requirements needed to enjoy a copyright protection. First, the work must be original. Second, the work must have been written down, recorded, or reduced to material form. Third, the work must satisfy one of the qualifications for protection provided in Section 10. Fourth, the work must fall within one of the categories of work entitled copyright, which includes literary works, musical works, artistic works, films, sound recordings, broadcasts, typographical arrangements of public editions, and derivative works. Firstly, in Section 8, Clause 1, Paragraph B, derivative works defined as collection of works eligible for copyright, or compilation of mere data, whether in machine-readable or other form, which constitute intellectual creation by reason of the selection and arrangement of their contents, and such work is to be protected as original work. In our case, the book that Concern edited is a collection of works including essays and other works like poems. Therefore, this book is a derivative work that will be protected as original work. The first requirement is the originality of the derivative works as stated in Section 7, Clause 3, Paragraph A, that the work must be original. In the case of Radiant Trading Sdn Bhd and Sin Besting Equipment Sdn Bhd, the court held original which did not demand original or inventive thought, but only that the work should not be copied and should be originated from the author. Furthermore, Long Hock being judged in the case of McNaway Enterprise against Sun Lian Hock had stated that the degree of effort, skill, and labor expended was inextricably linked to the originality of the work. In the present case, Concern is the editor of the book which had collected essays and other works written in relation to environmental pollution. Although the book contains very little literary content, they are protected as literary works because of the skill, effort, and labor that Concern had expended for the purpose of that book. So the third requirement is that according to Section 7, Clause 3, Paragraph B, the work has to be reduced into material form. In Section 3, material form is defined as any form of storage from which the book or a substantial part of it can be reproduced. If a work is not expressed in a material form, it simply remains as an idea which it does not own a copyright. Since the book has been published in January 2019 by Phoenix Sdn Bhd, the book has fulfilled this requirement. The fourth requirement laid in Section 10, Clause 1, which the author has to be a qualified person. In Section 3, qualified person means a person who is a citizen or permanent resident in Malaysia. In our case, Concern's nationality is not mentioned, but if he is a Malaysian, then he would have fulfilled this requirement, and Concern will have the copyright over the book. However, in Section 26, Clause 2, Paragraph A and B, when a person is commissioned by a person who is not the author's employer under a contract of service or apprenticeship is made in the course of the author's employment, the copyright shall be deemed to be transferred to the person who commissioned the work or the author's employer, subject to the agreement between the parties. In our case, we can safely assume that Concern, who is the editor of the book, is an employee of Phoenix Sdn Bhd. There is no mention of the conditions of the employment contract between Concern and Phoenix. If we would assume that Concern is working under his employer, Phoenix, although he had put on his skills, effort, and labor, the copyright would still belong to Phoenix as seen under Section 36, Clause 2, Paragraph B. For the second issue, where the critic has infringed Phoenix's right by reproducing a few lines from the book which was Pia's poem. According to Section 13, Clause 1, Paragraph A, owner of copyright has the exclusive right to control the production of his work in any material form in Malaysia. However, according to Section 13, Clause 2, Paragraph A, Phoenix's right to control the reproduction of the book does not extend to what critic did, if the action was done in fair dealing for the purpose of reviewing. In Section 13, Clause 2A, factors that constitute a fair dealing included the purpose and character of the dealing, the nature of the copyright work, the amount and substantiality of the portion used, the effect of dealing upon the potential market for or value of a copyright work. In the present case, even though critic had copied the substantial part of poem in which he reproduced such lines into his article that was published in local newspaper, it does not amount to copyright infringement. This is because critic was just reviewing the book in which he ended the article with the 4 lines. It was not to interfere with the sale of the book or to compete with it. A review itself will not bring any commercial benefit to the writer. Therefore, critic may raise the fair dealing defense that his review did not infringe Phoenix's copyright, but for as long as he acknowledged the title and author of the poem, Ashes, and Pia, as provided under Section 13, Clause 2, Paragraph A in that article.
The third issue is whether Mas has copyright in his translation. As mentioned earlier, 4 requirements are needed to be fulfilled to get copyright protection over a work. According to Section 8, subsection 1b, mass translation is a derivative work, therefore it can be protected by copyright just as an original work. The second requirement is in Section 7, subsection 3a, that it has to be original, subjected to skills, effort, and labor given. In our present case, the poem was initially written in Swahili by Kuan Chu. Mas has exhausted his effort, skills, and labor in doing the translation of Swahili work to Bahasa Melayu. This does not only show that Mas has put on effort in the translation, but also requires Mas' skill to be fluent in both Swahili and Bahasa Melayu. Therefore, he had shown the originality of his derivative work. The next requirement is in Section 7, subsection 3b, that the work has to be reduced into material form. In our case, it did not mention that Mas had reduced his work into a material form in which his work cannot be said to have expressed. However, as seen the facts that he had recited his work at a poetry reading session at English Department, University of Malaya in 2016, it means that he would have written it down somewhere in order for him to be able to recite the poem. Therefore, it can be safely assumed that it has been reduced into material form. Next, to get a copyright, Mas has to be a qualified person as stated in Section 10, subsection 1, that he is a Malaysian citizen or permanent resident. Assuming that Mas is a Malaysian, he has fulfilled this requirement. Since 4 requirements has been fulfilled, Mas has copyright over his derivative work. Issue 3b, whether Mas had infringed Kuan Chu's copyright. According to Section 36, subsection 1 and Section 13, subsection 1a, Kuan Chu has right to control Mas' action to reproduce the poem in Bahasa Melayu unless license is given, or else there will be infringement. However, assuming that Mas did not obtain license from Kuan Chu, hence there was infringement, but Mas' copyright will still be protected under Section 7, subsection 4. Fourth issue, A, whether PA has infringed Mas' copyright over the Bahasa Melayu version poem. According to the case of Hexagon Tower and Polydemic Holdings, 3 factors must be satisfied in order to prove infringement. First, must prove objective similarity between plaintiff and defendant's work or substantial part of it. Second, causal connection. Third, work that is copied is a substantial part of the copyright work. In the case of Goodyear Tire and Silverstone Tire, originality requires the work to originate from the author, also means that another person who creates his own independent work without recourse to any act of copying, has created an original work even if his work happens to be identical to an earlier work. In our case, Ashes was written in Bahasa Melayu, which is also similar to Mas' derivative work. However, there was no causal connection between Mas and PA, so there was no copying of work. PA's derivative work is original because it was an independent work created by his own and therefore he has copyright. B, whether PA has infringed Kuan Chu's copyright. Applying Hexagon's case, PA cannot be said to have infringed Kuan Chu's copyright just because there was simply a resemblance of the Swahili poem. Since Ashes is an independent literary work of PA and is not derived from the Swahili poem, no license is needed from Kuan Chu. So there is no infringement unless Kuan Chu could prove the 3 factors between the 2 works.
The 5th issue is whether Yami has infringed Kuan Chu's copyright by recording a song using the lyrics of Swahili version of that poem. According to Section 36, Sub 1, read together with Section 13, Sub 1, Item A, Kuan Chu has right to control the reproduction of a literary work, and if he did not give any license or consent, that person is said to have infringed the copyright. In the case of Rock Records, Sendirian Berhad, and Audio One Entertainment Sendirian Berhad, it was held that in a song recorded, apart from copyright in sound recordings, there was also copyright in literary works for the lyrics and musical works for the melody. In our case, Yami reproduced literally work of the lyrics of the song using Kuan Chu's poem in Swahili lyrics. Assuming that Yami did not get consent or license from Kuan Chu, he would have said to have infringed Kuan Chu's copyright. But his copyright will still be protected under Section 7 Sub 4. The sixth issue is whether Kuan Zu can publish the collection of his poems including Ashes in Bahasa Malaysia. As stated earlier, since P's poem, which titled Ashes, is an independent work, so it has copyright of its own. If Kuan Zu wants to include Ashes, he actually needs to require license or consent from P first, as required under Section 36 Sub 1. Then he can publish collection of his poem, including Ashes in Bahasa Melayu, under Section 8 Sub 1, Item B as a derivative work.